Thank you very much, everyone. So we will start again. Thank you for your comments. Some of these questions we maybe come to later on, but I wanted to just highlight the one that said know the why and convinced by that, as many of us are, but need to know more on the how. Very useful segue into the next conversation. So this morning we touched on why we might think about incorporation of international standards in domestic law. We now want to turn to how this might be done in Scotland. What are the models and what can we learn from elsewhere? So I'm delighted to lead this conversation to introduce Dr Katie Boyle. Katie is the Senior Lecturer in Law at the University of Roehampton and will shortly take up the position of Associate Professor of International Human Rights Law at University of Stirling. She's currently serving as a member of the First Minister's Advisory Group on Human Rights Leadership. Katie has published widely on economic, social and cultural rights, justiciability, incorporation and comparative constitutional law. Her research interests include exploring remedies for violations of economic, social, cultural rights in different constitutional settings, including Scotland. So Katie wrote a report for the Commission on Incorporation in 2015, and we will be publishing an updated version of that report in the next few months. So do look out for this or subscribe to our mailing list under the new GDPR regulations, of course, to receive a link. So I'd like to now hand over to Katie to take you through the next session. Thank you.
Thank you very much. Can I just first of all say thank you to the Scottish Human Rights Commission for inviting me to speak today, and also for affording me the opportunity to take some time to look into the issue of the what, the why and the how of incorporation and justiciability in relation to economic, social and cultural rights. Just to give you a little bit more of a background to how I came to this area, I was 14 in 1998. When the Human Rights Act was passed. So to me, I very much feel like almost a child of the human rights era in the UK context, and of course a child of devolution. And since then, I had a lot of opportunity. Sorry.
Speak into it. You can sit back. It's okay.
Swallowing the mic. You can hear okay from here? Yeah. So since then, I took a great interest in human rights. And when I was 14, I went to work in a law firm in Tory Glen in Glasgow, which is where my school was. And I became acutely aware that the lived experience of people's everyday lives touches on all areas of human rights. And in the spirit of the Human Rights Act and devolution, I saw what was at the time, and certainly what the legal profession was looking at, was the ways in which the Human Rights Act and human rights laws could better help people in respect of their everyday lives. And it wasn't so much later in my legal career, having gone to university and worked as a trainee solicitor and then also studied further postgraduate study, that I became acutely aware that there are actually quite sizable gaps, which mean that not all human rights are accessible through the statutory provisions that we have in the UK. And so many of the difficulties that people faced in relation to health, housing, social security, education, work, they were partially protected under different aspects of our statutory provisions, but they weren't fully protected. And so from my perspective, that has been something which has been really important as a driving force in looking at this area of law from a researcher perspective. And I'm here to speak in my capacity as an academic. And I feel that it's been a great privilege that the Scottish Human Rights Commission have prioritised this area, and that I've had the opportunity to therefore take some time to investigate and research a little bit more, particularly around the how of potentially improving the human rights framework should Scotland choose to do so. But I'm also acutely aware that there are many in this room who have more experience than I in civil society, for example, working with people every day at the coalface of human rights violations, and also more experienced people from the constitutional legal background. And I have to say I've spotted at least 4 of my previous supervisors when I was a trainee with the Government Legal Service. This is like a nightmare. I think I've definitely had this dream. So I... Thanks. So it's really been something that, as I say, has been a privilege to look at. But I am acutely aware that this is, in one sense, a very simple question. How can Scotland better protect its human rights? How can it improve access to economic and social rights? And in another way, it's an extremely complex question because of our particular constitutional framework. And so when I'm going through these slides and discussing this today and in the forthcoming report, I do recognise the fact that I certainly don't have all the answers, but what I think is really, really important and what the Scottish Human Rights Commission has done is started a conversation and is taking steps to make sure that conversation is informed. And so that is what really has to be welcomed. And I'm so grateful to all of you being here today, because this will take more than a small group of people to bring forward and looking at innovative ways that Scotland can improve its human rights system, if at all. And I think that's what's really important to mention. As you present these options, it's about increasing awareness and ensuring the conversation is informed, rather than me advocating for one position or another. So I thought I'd just start with mentioning that, and I also just want to mention one other sort of caveat. Having had the opportunity to reflect a little bit more on the what, why and how, I find that as an academic I have to engage both locally, nationally and internationally. And there is a degree of frustration from my point of view that when you engage at the international level, or say, even in the European sort of level, there are very different conversations that happen about economic and social rights. And sometimes the frustration from my point of view is that there is a sort of antagonism and a reluctance to engage with the legal status of economic and social rights in the UK context. And so sometimes it can be hard to move the conversation on to legitimate and viable potential mechanisms that could operate, because we get stuck in this justiciability argument. So it's really important to also say from the outset that when I started undertaking research in this area some years ago, I found that economic and social rights are enforced to different degrees under many different mechanisms and are justiciable in the UK every day. It's just that they are often made justiciable under the rubric of something else. But it is important to make that point, because we really don't need to get caught up in whether or not they're justiciable anymore. It's about moving the debate on towards how best they can be made justiciable and how best that we can create a system that works in the best way for the particular constitutional setting in Scotland. So the questions that I have been given to address today are: how do you incorporate ESC rights into Scots law, and how do you make ESC rights justiciable in Scots law? So if we just start again, and I'm going to ask that everybody in the room almost sort of puts to side their experience or knowledge around the Human Rights Act, Scotland Act and ECHR framework. Just to bear with me, we'll revisit it later, but just to start from a clean slate. Because often when you look at the area of incorporation, what the literature tells us is actually really good examples of incorporation of international and regional mechanisms are the ones that exist in the UK. So the Human Rights Act and the Scotland Act are good examples of how to incorporate, because they take an international, or they take a regional convention, and the law partially transplants it into the domestic framework in a dualist state. So it's actually often referred to as an example of good practice. However, and I'm going to refer to an analogy of how the human rights framework is like a tree. At the source of international human rights, Virginia already mentioned, we have the Universal Declaration of Human Rights and its 70-year anniversary. At the centre, the sort of core trunk of human rights is the Universal Declaration of Human Rights. You then have all these various branches that split out at the international level and at the regional level. We have many different treaties and conventions which progress our understanding of what human rights are. And in the UK and in Scotland, we have essentially borrowed one branch of this international tree and embedded it constitutionally through two different means, through the Human Rights Act and the Scotland Act. And the main problem with that is that all the other treaties which deal with the European and social European social and cultural rights have not been transplanted in the same way. So immediately we can see through this sort of analogy that it's about how do we take those other branches and make them realisable within our particular constitutional framework. It's also important to remember that economic and social rights, as I said, are already partially enforced to different degrees through various different mechanisms. And I've just listed some of these here as examples from research that I'd previously undertaken for the Commission in 2015, where I looked at where economic and social rights can be made justiciable. So you may, for example, see economic and social rights issues coming up under the rubric of equality legislation. For example, in Birmingham, not long after the enactment of the Equality Act, we saw that there was a case taken where Birmingham City Council had reduced funding for people that were disabled. It was challenged because they hadn't had due regard to the public sector equality duty. And as a result, the decision was quashed by the court because the council hadn't fulfilled its statutory obligation. So it was justiciability around a socio-economic issue and a socio-economic right. It just wasn't under the rubric of the international system in its fullest sense, but it was engaged. Likewise, you'll see that socio-economic rights are also partially protected under civil and political, such as the European Convention of Human Rights, which to some degrees, as Kavita mentioned, partially protects economic and social rights. But the treaty is limited in the sense that it is not designed to reflect the full body of international human rights law. Now, if you go back to the preparatory work to the European Convention of Human Rights, it is quite clear that that was how the treaty was designed. It was to be followed with an economic and social rights charter, which did follow suit. And the drafters of the European Convention of Human Rights were actually drawn, the UK delegation was Scottish lawyers who were very keen to make sure that when they were implementing the provisions of the European Convention of Human Rights, that it was clear what instructions were being given both to states and, if it comes in court, what kind of instructions were being given to judges. So they were very much at the forefront of that as an innovative mechanism. But often you will see socioeconomic rights being adjudicated upon under Article 3, under Article 2, right to life, under Article 8. It's just that the treaty can only go so far because it is inherently limited by its construction, and that's the way that it was designed. You'll also see, and particularly in the UK framework, and as Virginia mentioned earlier, there is a predisposition towards favouring legislation as the most appropriate means through which to enforce economic and social rights obligations as defined in international law. However, often economic and social rights, when they are enforced through legislation, are not enforced with reference to international legal obligations. So what you might see, for example, is something like the National Minimum Wage Act, which is designed to provide for a fair wage for people that are working, is introduced, but not with reference to the international legal obligations. And so there is a gap between the legislation that's introduced at the domestic level and what the normative expectation is in international law. So it's about trying to close that gap. Is there a way that you can structurally provide an overview with reference to international human rights that ensures that legislation reflects international obligations insofar as it is possible to do so? You also have, for example, socioeconomic rights enforcement under other means such as EU law, constitutionalisation, which Virginia spoke a lot about, that many countries take different approaches to enforcing economic and social rights in their constitutions, either explicitly or implicitly. And so when I'm speaking about incorporation within this session, I'm taking the widest possible definition of that and looking at it from the point of view when constitutions are passed that give legal status to rights that are also international human rights, that is a form of implicit incorporation. That's a bit more difficult to give effect to within the UK framework, of course, because there is no codified, or there is no written constitution codified in one place. So we do have a difficulty in that respect, that we can't easily necessarily borrow from other countries, but we can still learn from different approaches. And I think what's important is that, particularly within the devolved context, we can take lessons, for example, from other federal, provincial types of constitutional settlements. And finally, we have the regional international complaints mechanism as another way of enforcing economic and social rights. So, for example, the European Social Charter has a quasi-judicial function attached to the European Social Committee. However, the UK hasn't signed up to that collective complaints mechanism. So we have an accountability gap in respect of the fact that cases can't be taken to that regional complaints mechanism, even although the UK has signed up. Now, again, within the Scottish context, this is a little bit more complicated because Scotland can't unilaterally sign up on its own. It has to be, it would have to come from state level. So we can see that there are various degrees through which incorporation of economic and social rights might happen, but they'll often be restricted and they'll be under the rubric of something else. And so what the research is asking, and the questions that I've been looking at, is can we take a more holistic approach to this? If there is a gap, can we come up with ways with trying to address it? And that's the question that, in one sense, is very simple. Just extend, for example, the incorporation that we currently have through the Human Rights Act or the the Scotland Act, where you could, for example, say, well, let's introduce a treaty such as SHRC, which covers economic and social rights. But then it's also very complicated in the sense that we have a particular constitutional framework under devolution where we need to think innovatively about how that might be possible. So just to capture those different means in the literature, when we look at this as academics, we might often see what's referred to as ports, where international law enters the domestic legal system in a dual estate through various ports. So you have, for example, legislation acting as a port, such as the Human Rights Act, common law, where the judiciary make advancements in relation to economic and social rights by extending protection under the common law. And ZH Tanzania is a really good example of that, where Lady Hale takes the UNCRC and says, you know, there is enough evidence here that the Parliament intended for this to be a standard to which they hoped government would be held accountable to, and so you have the best interests of the child provision becoming more embedded through the common law. You also have, for example, international complaints mechanisms. I've already mentioned that it's slightly more complex, that Scotland might not have the opportunity to do that unless the UK takes the lead in that respect. And then you have constitutional arrangements. And when I speak of constitutional arrangements, I'm not just speaking at the national level, but there are subnational examples where constitutional arrangements allow for international human rights to be embedded in domestic legal frameworks. This is a list just going through an excellent site called constitution.org, where all the constitutions that have been set out internationally, you can go through and search through what different rights are protected. And I did some searches looking for explicit and implicit protection of economic, social and cultural rights. And these are some of the countries that came up. The ones that either explicitly or implicitly, to various degrees, incorporate or embed international human rights, including economic, social and cultural rights, in their constitutions. Is Scotland next? I mean, really, it's just to highlight the fact that this is not that unusual, comparatively speaking. And I spoke earlier about the frustration at when you have conversations within the UK about, you know, it comes down to, you know, is incorporation possible because justiciability is not? And actually, when you have those conversations across Europe or internationally, it's very, very different. So you almost feel like you have to prepare for two different types of dialogues in this area. Professor Colm O'Cinneide, who's speaking later, has written about that sort of concept of European social constitutionalism, which is embedded in other countries. And actually, for us to have that comparative dialogue, we need to try and reframe how we think about this. Because, to be perfectly frank, other countries have moved on much, much further than we are in the UK. And Scotland, I really think, is important, does not get left behind in that respect, when there's very strong political impetus and excellent lawyers in the room with the ability to think of innovative ways of making that a possibility within our particular constitutional framework. Just to revisit this, and again, this comes down to my simple and complex dichotomy, because in many respects it's very simple for Scotland to exercise its power. As Lord Brodie has said in Whaley and another, Scotland has the power to implement and observe international human rights obligations if it chooses to do so. So the way that our constitution is designed, it's not actually a duty that's placed on Parliament, but it is a competence and a power. So you can exercise the power to implement and observe international obligations should you choose to do so. And you can do this in devolved areas. So it's the mechanisms through which best to achieve that is the question of the how, rather than whether or not it's possible. Comparatively speaking, when you look at how different constitutions do it, you'll see that there is almost a multi-institutional approach. And I find this a really helpful way to think about incorporation. So rather than just think of it as a clause in a bill that says all these treaties are now incorporated, which could be hugely problematic because it doesn't necessarily set out the means through which that ought to operationalise itself. If you think about incorporation as something which touches upon all institutions of governance, you can see that it could place duties, for example, through whichever means that you take, on the legislature, the executive and the judiciary. And so actually incorporation is about building in mechanisms for pre-legislative scrutiny of legislation before it's passed. It's also about creating the executive, administrative operationalisation of economic and social rights, where duties are placed not only on ministers but on all public bodies, whatever kind of duty that might be, to either comply or have regard to international human rights law, including economic and social rights. And then you can see that you can place duties on the judiciary to uphold those rights. So again, coming back to what I mentioned earlier about the different types of conversations you have nationally and internationally. Internationally, what you'll see in the literature and in practice is about how the judiciary can meaningfully engage with rights by actually helping to give them meaning. And it's not about the judiciary usurping the role of the legislator or the judiciary usurping the role of the executive. It's about how to enter into constitutionally sound dialogue in a deliberative way. So there are many means through which you can do that, and it's about trying to reframe the way we think about judicial intervention. And if you, for example, just think about the difference between remedies available under the Human Rights Act compared to remedies available under the Scotland Act. Under the Scotland Act, you have the ECHR, which is constitutionally embedded, so the Parliament, Executive and the Judiciary can act incompatibly with it. If they do so, you can, for example, the legislature can strike, the judiciary can strike down legislation which is incompatible. It's a very strong type of remedy. In comparison, under the Human Rights Act, we have what's called the Declaration of Incompatibility, which has no effect on the law which is not compatible, which is a different type of remedy. One is much more robust than the other. But we place these two types of remedies at opposite ends of potential intervention. You can find that there are very meaningful and innovative ways where the judiciary can intervene and supervise in the compliance of human rights without necessarily having to strike down law or just issue a declaration of incompatibility. So it's about trying to work out what kind of dialogue you want to encourage between institutions within governance, and incorporation should be seen in that much broader sense of accountability, an accountability culture in relation to compliance with international human rights law. So this has been the great fun part of my research, where I've looked at various different countries, and I'm so delighted to to have some time to talk about it. I mean, I really, honestly, I'd speak about this all day, so I will be wary of time. It's absolutely fascinating to look at the different ways that countries approach this. And as I say, you're very much in the unusual camp if you do not engage. It is much more common that this is something countries have to engage with. I mean, as Virginia mentioned, if you look at post-conflict countries, it's something which is almost fundamental to peaceful transitions that you address economic and social rights violations. And if you don't, the country is less likely to make the transition to peace. Because essentially it's about fairness and governance in a way that does not exclude people. And so it almost seems, that it's self-evident that you would not just have civil and political rights, but that you have mechanisms in place to ensure that economic and social rights are given legal status and are part of that framework. To be in the position where they are essentially not even remotely engaged with in a constitutional sense is quite unusual. So I thought it would be helpful to just split out the countries that I've referenced here, and there are many more, in relation to the different ways that you will see incorporation happen. So if I take, for example, the constitutions of Finland and Switzerland, I mention them because they are countries which place quite a large degree of the responsibility for compliance with economic and social rights and international human rights more broadly within the legislative branch of government. So the Finnish Constitution, anticipation. The Finnish Constitution has this really fascinating approach where you will see that rights are protected explicitly in the Constitution itself, and the way that it's worded is you'll see that the Constitution places an obligation on the legislator to bring forward an act to comply with a particular right. So, for example, the legislator shall enact law which protects the right to social security. That's how the Finnish Constitution operates. So it places a strong obligation on Parliament. And then within Parliament itself, you have what's called a Constitutional Law Committee, which is a depoliticised to many degrees, as much as it's so possible to do so, a committee which examines legislation before it's passed to ensure it complies with the Constitution, including economic and social rights. So the Constitutional Law Committee has strong powers to intervene pre-enactment, so pre-legislative scrutiny, which is also called ex-ante scrutiny. And for example, just to give an example of how that might operate, the Finnish Parliament sought to introduce welfare reforms where they were going to reduce the amount of social welfare someone could have access to if they were living with their parents. So it was part of an austerity measure, and the Constitutional Law Committee had a concern that that would mean that some people would be very vulnerable because perhaps the parents wouldn't have the means to give them that extra support, or they could, for whatever reason, be unable to. They may be not living with family or not have good relations with family, so it was potentially discriminatory in that respect. The Constitutional Law Committee took evidence from experts who said, yes, this is a problem, it's arbitrary, it's not a good idea, you need to rethink it, why don't you do a means-tested policy in the legislation? And so the legislation was changed to comply with economic and social rights. So it's ex-ante review, and it's hearing from experts in human rights and constitutional law to make sure that the legislation is compliant beforehand. So that's an example of a very strong emphasis on legislation and pre-legislative scrutiny. Switzerland I wanted to mention because in Switzerland you have a system in which when the state signs up to international human rights law, it automatically is the responsibility of the cantonal legislators, which are the devolved legislators in Switzerland, to comply with the state's international human rights obligations. If they do not do that, then they put the state at risk of being in violation. So it almost flips our way of thinking about state responsibility, particularly if you think about Scotland in the context of devolved areas, many of which engage with economic and social rights. Under that system, there would be a very strong emphasis on the devolved legislator ensuring that international human rights compliance occurred at the devolved level to ensure that the state was in compliance with international human rights. The executive, I just wanted to mention the South African Constitution and also the German Constitution. Just to give you an example, in South Africa there's a very strong constitutional arrangement where post-apartheid economic and social rights were given a great degree of protection in the Constitution. And as part of that, there was a means through which to ensure things such as the right to housing and the right to healthcare. Again, it was implicit recognition of the international human rights framework rather than an explicit clause which referenced all international human rights treaties. And under the South African Constitution, it was one of the first constitutions which really grappled with the everyday justiciability of economic and social rights. And there's great stories that go around about how when that first happened, the judges needed help. They weren't exactly sure how that was going to work in practice. And the lawyers and the constitutional advisors and the judiciary all had to undertake a learning curve, a steep one. And there were stories of, sometimes the lawyers would drop off books at the judges' houses anonymously in the hope that they might have reference to. So, that's my next step.
That's my next step.
So that's what it takes, because it does take a new type of culture, and really to step away from this fear that you create a litigation culture which completely which creates an imbalance in the way constitutions work. That doesn't necessarily have to happen. There's very sensible ways through which to make human rights justiciable and effective. So in South Africa, for example, there was a case where around 900 people were removed from an area of land where there was they were living in a sort of a shanty town arrangement, and they were cleared off the land and they moved to privately owned land and set up a similar housing arrangement. Now, under the South African Constitution, there is a right to adequate housing. And so one of the residents, Mrs Grootboom, took the case to the Constitutional Court and argued that her right to housing was being violated. Now, they had been the town that they had built had been essentially burned down and they'd been evicted. They didn't have access to housing at all. And when the case was heard by the court, as I say, they engaged with this area, but they looked, rather than enforcing an immediate right to housing, they looked at whether or not the state had taken a reasonable approach to housing. And they found that its policy around fulfilling the right to adequate housing was unreasonable. So it was essentially reviewing the rationality of the state's approach. They recognised that there was not necessarily the resources there to give everyone an immediate right to housing, but it was important that the government was able to justify that it was taking reasonable steps to fulfil that policy, and the court found that it wasn't. And so the right to housing was fulfilled in this broad sense that the court intervened to say you need to rethink your policy and you need to introduce one which is reasonable and which tries to achieve the aim in the quickest, most proportionate way possible. Now, that's an example of placing quite strong emphasis on executive responsibility, but it didn't necessarily mean that there was the immediate access to housing for Mrs Grootboom. So it's just to give an example of another type of approach where this is quite deferential, and it's also about a balancing approach in terms of reasonableness, which is something we're very familiar with in our own legal system in terms of review. And then you also had the example of Germany, in which there was an obligation placed on the executive to ensure that when it introduced welfare reform, that it did so in a way that complied with human dignity. And human dignity was used as a threshold to ensure that human rights compliance occurred. And again, there was quite a strong emphasis, so the judiciary looked at it and said that not only was the policy unreasonable, but there had to be an immediately realisable right to what was a minimum of human dignity in that scenario. And finally, still on the, just to emphasise the very progressive ways courts can get involved. For example, in Colombia and Argentina, what you will see is that in the Constitution of Argentina, where it does have a form of direct incorporation referencing all international treaties that the states signed up to, and you also have a federal sort of provincial setup, you will see that the court will take quite radical steps to enforce the right to housing, for example, where after a series of interventions from the court, which was quite deferential, eventually it took steps and said when there were a group of people that were being displaced from housing, they ordered public funds to be seized. They ensured that all the cases were dealt with collectively, that they introduced a policy, the local authority had to introduce a policy to ensure housing was fulfilled, and that the business which secured the tender to fulfil the right should also employ local residents as part of that. So you had a procurement aspect of that, also encouraging compliance with the right to work and fair employment, and that it was adequate and affordable. So this very broad structural approach where the court took great steps, and you'll see similar things in the Colombian constitutional framework, where they have a system called tutelas, where you have this fast-track process for people that are in desperate and immediate need. And when you have a situation where it transpires to the court that the same case keeps coming up again and again, say for example you have a scheme of housing where the same problems are faced by all the residents, in that scenario the court can group those cases together and deal with them structurally as one issue and give remedial orders which give different branches of government responsibility to ensure compliance. So it's a very interventionist approach, and it creates a framework where there is a strong emphasis on compliance in that respect. So that gives the very broad overview of different kind of ways through which incorporation might occur. And as I say, it's almost like a multi-institutional approach to incorporation, where different branches of government have responsibility and at the same time all have a responsibility to hold the other branches to account. I mean, that's basic constitutional separation of powers. But the judiciary in that framework, you could arguably say, would be abdicating their role if they didn't, to some degree, review compliance. So it's about giving clear instructions in terms of what's expected. This table here, and I realise it's perhaps too difficult to see it in great detail, smaller text, but it basically just recaptures what I've said there. You can have means of incorporation, roles on the legislative, executive and the judiciary, and you'll see that there are different degrees of weak or strong protection of economic, social, cultural rights, depending on how much emphasis you place on each of those branches of government having to take steps to comply. Now, this table gives some examples of ways forward that Scotland might consider. I thought that Claire's question earlier was excellent. Why don't we do this? And it isn't it's not a question that I can answer either. But what I think is important is that we start the conversation on what's actually feasible, legitimate and viable. And I don't have all the answers to that, but what this does is suggest some ways forward that we might start considering it. So you have, for example, the Human Rights Act model and the Scotland Act model. I mean, technically you could take steps where you ask Westminster to change those acts. Highly unlikely that would happen. But that would be a form of extending those acts to include a form of international law which included economic and social rights, including we have a European framework for that. There is SHRC and there is also the European Social Charter, two versions of which the UK's only signed up to the earlier version. So it's just about the potential options. You could also think about what might be possible under due regard duty. So we're familiar with it in the context of equality, but also the Welsh measure from 2011 introduces an obligation to have due regard to the UN Convention on the Rights of the Child. Now, this is obviously a really positive step forward and demonstrates devolved ability and competence to take steps to enhance regard to international human rights law. But it's just important to mention within a legal context, a duty to have due regard is a type of process. Is a type of process duty rather than an outcome duty. And the reason that I mention that is because it affects the type of remedy available. So if you think about the way that the public sector equality duty operates, you have to have due regard to different protected characteristics and equality, but it doesn't necessarily result in a favourable outcome. It may, but it may not. And when you demonstrate that you fulfilled that duty from the decision maker's point of view, you don't need to justify necessarily why the outcome doesn't achieve a particular aim. You just have to demonstrate that you undertook the process of having due regard. And that's just an important difference to highlight, because it will not be as enforceable as a substantive outcome as other types of duties. The other way through which you can enhance protection is through an international complaints mechanism. I've already spoke about the limitations in that respect. Common law, you can rely on that, but I think perhaps unrealistic to expect the judiciary to pick up that mantle without giving them clearer instructions, and this is what this is essentially about, explaining to the judiciary what's expected and Parliament taking steps to set out those instructions clearly. And finally, enhanced parliamentary scrutiny, which is something very much a possibility within the Scottish context for the Equality and Human Rights Committee, which is undertaking a human rights inquiry at the moment, could enhance parliamentary scrutiny of economic and social rights. This is something that could also be enhanced within the Westminster system, perhaps not totally, reflecting the Finnish model to the same degree, but certainly learning from it and making it part of the pre-legislative scrutiny process. Yeah, I'm just finished, yeah. Okay. So just to touch upon the aspect of justiciability, and it's something that I wanted to finish on in this respect. The Lord Advocate, prior to his appointment, had spoke at an event at the University of Edinburgh in which he set out the options, or set out that justiciability of economic and social rights, it doesn't actually have any conceptual barriers in relation to taking it forward. It's just about creating mechanisms through which it might happen. So just to highlight that, it's about exploring the ways through which it can occur, not whether or not it's possible at all. In relation to justiciability more generally, I also wanted to highlight the fact that there are different forms, or there's a journey that has to be undertaken, and so we can't look at justiciability in isolation, because, for example, you may make rights justiciable, but you may not have access to legal aid or rules regarding standing which allow cases to be taken forward. If we go to the next one. And I'll just finish up on this slide here. It's basically just highlighting the fact that, like I say, a due regard duty will not be the same as a duty in which you expect a policy to be introduced, such as in relation to the group home case, which is different again to an expectation of an outcome where you have a substantive enforcement. And so it's almost a degree of enforcement not dissimilar to respect, protect, fulfil, but if you try and think of it in an axis of realisation, and depending on the type of duty you enforce, you will have a different type of outcome. And so we need to think about that in the context of when we're looking at justiciability. Sometimes it will be more appropriate to have a more deferential approach, and other times you may require something more robust. And just the final slide is to highlight, skip again, that the way that we perhaps overcome some of these difficulties and scepticism around justiciability is to try and rethink the way that remedies operate. And like I say, in some respects, we may need to have something which is something like an ultra-vires remedy, where you have to intervene in very strong and robust terms because someone is in immediate need. Whereas you may have more deferential approaches on other issues where you might say, for example, steps need to be taken. And it's about trying to find the different ways through innovative judicial remedies, such as supervisory functions, perhaps collective collective cases, that we need to rethink perhaps some of the ways that happens. And I'll just finish on the very, very last point before we move on to the activity, to say that justiciability is not about changing the culture that we expect human rights to be enforced because we make rights justiciable. Justiciability is about ensuring the court is there as an absolute last resort. It's not the first port of call, it's the last port of call. it should already have happened, but it's about creating an accountability mechanism that gives people that extra protection, that they know if the decision makers and duty bearers don't take those steps, that they have something to fall back upon. But you can introduce mechanisms like all other remedies must be exhausted first before you get to the judicial element. So it's about creating this overall structure and possibility. So what we're going to do is turn to our activities.
Do you want me to go through this, or you want to go?
Yeah, if you've got something there.
Yeah.
Yeah, perfect. So I'll just hand you over to Judith to take forward the next part of the session.
Great. Thank you. Thank you so much, Katie. Excellent, really helpful clarity, actually, on what our potential options are and the range of them, and the possible answer to the question, Claire, in terms of what's stopping us. Not a great deal in practical terms, but maybe many other things to overcome as we go through this process. So, for the first time this morning, you are actually now going to have a serious chance to engage with this material yourselves in discussion at your tables. So you have, I think, facilitators at each table, and we're going to ask you to engage with some of this information for yourselves to really start to sort of grapple with some of the conversation we've had. We've got two